It is now 10:49. I am calling the meeting back to order. Eileen.
Well, I have a couple of thoughts. The first is to remind everyone it isn't whether things are worthwhile. It isn't whether things are good. That isn't the question. The question is, will it survive under Janus? That's the issue. And there's been a fair amount of comment that if it were a voluntary bar, people would leave, which would kind of reinforce the point that as a mandatory association, there are people with issues who have potentially First Amendment rights and would exercise them. I agree this does leave people in limbo, but we are in limbo until we have some clarification, if you want to call it that, or ruling, guidance from the U.S. Supreme Court. However, I would put money on the table that there will be a lawsuit in Washington if we do nothing. And if there's a lawsuit, then somebody else is going to decide what happens. And there'll be more limbo with litigation. So I think, and I may not have expressed it as clearly as I could have at the beginning, that we should evaluate what our, and I don't mean us as a group, for example, to evaluate the financial considerations, but we should identify potential issues and then say what are the consequences or what information needs to be gathered, particularly on the financial question, if the Supreme Court says association means that you do not have a mandatory bar association if that bar association takes positions outside of a very narrow regulatory issue. I think that it's a matter of fairness to the employees, to the bar members, to begin to gather that consequence, because I also think it may influence the decision or a ruling on how broad or narrowly to scope a bar. It might be, we've heard a lot of kind of general discussion, but if we were to try and identify what in Washington we view as regulatory. In Nebraska, for example, the court there decided that the Client Protection Fund would be part of the voluntary association. I think that's a pure protection of the public, but obviously the Supreme Court of another state disagreed. So it seems to me that there may or may not be agreement about what is regulatory, and perhaps we could start with some things that we agree on as recommendations to the court.
Thank you, Eileen. I think that might be a good starting point because I think that would help us at least define the regulatory area, and for sure regulatory, no matter what we end up with, that is one, and we can see the ones that there's easy consensus, and then maybe have a little deeper discussion of ones that aren't, and sort of do pros and cons as to whether should be in or out. If we do it, if there anything, but even tweaking, that would sort of, perhaps we have to establish certain lines. The court does approve the Client Protection Fund. We get a report every year on it as to the decisions. So it's all good to go back and think about how it's all currently structured now. All right. Other comments from the work group members? Mark Johnson.
I just have to disagree with you, Eileen, that when you frame the issue, will the Bar Association survive Janus? I don't think it's that clear or simple. I don't think you can take that case, put it on top of Keller, and say that they apply. Janus was a case that held that a non-union member of a public service union doesn't have to pay any agency fees. And that's the limit of the holding. They are not officers of the court. They are not regulated by the judiciary. You can go on and on and on. There's multiple distinctions. So I think that framing the issue that way, I mean, we are here in large part, I agree, because of Janus, and I think Janus has to be considered. But the distinctions, we could sit here, go around the table, and we could probably come up with 20 between our bar association, lawyer regulatory systems in the 31 or so states that are mandatory bars, and a non-union member of a public agency union who says, I don't want to pay any agency fees. So I agree with a lot what you say, but I just don't agree with the way you frame the issue.
Well, if I could just respond, I'm not saying that that's the issue. What I am saying is that there are consequences to whether things are in or out. And we should not wait to consider what those consequences are. And we should be prepared to defend a decision to keep something in or out. If we don't, then it will be up to someone else. It will be up to a judge to make that decision. And I'm not actually saying that we should take any action now. I think it's premature at this point. And it does leave people in limbo, but it doesn't mean that they won't be in limbo if we take some action and the Supreme Court either rejects it or supports it. We will have made a decision that in advance. But I don't think saying we can just keep going, fingers crossed, hope for the best, and not think through some of the consequences if, as for example, Dan's email said, the bar structure were to change, there would be a significant loss of revenue. I mean, these issues just need to be considered.
Well, I think there is, I'm sorry, Andrea. I'll have you go first. No, I didn't see your hand, so I'd like you to go. Thanks.
I'm a little bit under weather, so hopefully I'll still be somewhat coherent. I take the implication of what we leave in and what we leave out to be directly related to the access to justice issues and the diversity and inclusion piece of it. I took the earlier comment about it's not a determination as to whether or not it has value, whether or not it's worthy, to be related to that. And then your question about it's whether or not it will survive Janus or whatever, under whatever analysis, is it going to hold up? And I cannot help but think that when these historical challenges have come up as they relate to individuals in underrepresented groups pushing for change, we have not always had something that we were trying to survive. It was just a matter of pushing forward. You may have not had any precedent on your side. It was just a matter of standing for what you believe to be the right thing to do, standing for the values and the integrity of the positions that you believe to be just. And so I think that I would urge us to sort of be very clear about where we stand on those issues and start to carve out a path, a legal path, to being able to defend those. I think that that's the real direct question that is before you. And I don't think that we should skirt around that. That's what's on the table. And either you take the position that we are going to find a way to make sure that these programs and these parts of what we believe to be essential to the practice of law or the legal profession, we're going to find a way to articulate and defend that, or you're going to just take the position that you're not going to. And it's not an indictment on anyone in terms of where they stand, but it is a clear call for us to sort of be, very explicit about that. I thought it was interesting that Fred, can I call you Fred?
Absolutely.
Thank you, sir. that Fred noted the preamble to the rules of professional conduct. The diversity committee met this weekend, and one of the things on their agenda was looking at, in a very deliberate and reflective way, thinking about spaces and areas in the legal profession where we have been very clear and articulate about the legal profession and its obligation, its role as it relates to this monumental idea of justice and protection of the public. And they were looking at that language, that a lawyer is also a public citizen having special responsibility for the quality of justice. Some of the other things that they were looking at was the attorney oath in Section 7 and 8. I was trying to find those, pull them up. And other areas where we've made it very clear that issues of equity and inclusion are essential, even so far as in our GR 37, talking about that in the context of jury selection. So we have spaces carved out where we have said that these are issues that are essential to how we look at and how we analyze issues of justice and equity. The other documents that we were looking at was the civil legal needs study and the intersectionality study that was done. I think both of those documents are available on the BAR's website. And some of the numbers in there, overall, 89% of WSBA's members are white, compared to 72% of the state's population. Some of the conclusions: having a diverse, inclusive, and representative bar is essential to serving the public, ensuring the integrity of the legal profession, and championing justice. These are the ideas that I'm asking you to defend when you say this is critical to what we think competency core lawyers or legal professionals in Washington state. These are essential. There's an intricate nexus there that is inextricable from one another. One of the other conclusions: the clear challenge ahead for the legal profession is to ensure that attorneys from underrepresented groups succeed in the practice of law. These individuals must have meaningful opportunities for leadership in the workplaces and the working profession. Diversity and inclusion, those get right to those issues. The access to justice issue, we were at, what was it? Who was there with me? Sorry, my mind is all over the place. The listening tour, The listening tour. Tara and Bill, yes, were there. And first of all, you guys did a great job. Thank you for that. One of the things that came up again was, access to justice issues and the triple T. People continue to be very perturbed about triple LTs. But again, it is an access to justice issue. People cannot afford lawyers. And so, again, it goes back to, I think, you being very clear, us being very clear, and being unapologetic about saying that in Washington state, here's what we prize in those individuals that we're going to license as legal professionals. You either got to be willing to take that stand and go to defense of it or not. And I think that that's the critical question that we need to stop skirting. And those are my incoherent, inarticulate thoughts.
You're very coherent, and thank you, Andrea. Andre.
Thank you, Andrea. I think that your points are well noted. I also think that a function of this board is to, or this work group, is to kind of stay away from politics, so to speak. I think they're the 800-pound gorilla in the room always, but to the best extent that we can, we want to be apolitical and be looking at and have some fidelity to the law and our charter. I think your point is duly noted with respect to the overlap to access to justice and diversity and inclusion, and I think if the work group members haven't reviewed the ABA model rules for the regulatory objectives for provisions of legal services, I think that's critically important for us to kind of take another look at. And I'll read directly from it because I think it makes your point. The relationship to the legal profession's core values is page 3, subsection 3, and it talks about the regulatory objectives are different from the legal profession's core values in at least 2 respects. First, the core values of the legal profession are directed at the legal profession. And by contrast, the regulatory objectives are intended to guide the creation and interpretation of a wider array of legal services. And so, yes, Washington is a leader with respect to access to justice and diversity and inclusion, and I don't think we're going to dovetail away from that, despite efforts. And I think if there are challenges made to those, I think we have enough inertia, enough programs and systems in place to defend that position. So I don't think that that's going away. I don't think that that is something that we need to necessarily be engaging in litigation risk analysis for. To Eileen, your points regarding, again, I think a lot of your statements are related to litigation risk assessment. and obviously you'll get a chance to respond, but I think that's outside the scope of our charter. And that may be another work group that needs to be convened to look at those situations. But certainly, I agree with Mark that a lot of this stuff is going to be copycat, whether we do something or not, and we can't predict that. So, to Andrea's point, I think diversity and inclusion and access to justice are a part of our regulatory objectives that we don't seem to be monkeying with now. So that's going to survive. I don't think that's necessarily on the chopping block. It may be a desire to address it, but I don't think it's going anywhere. I think Washington is a leader with respect to that. And then with respect to Janus and compelled association, I never thought about Washington lawyer being an opt-in situation, but maybe that's how we remedy that, because I don't know where other instances arise where there is First Amendment issues per se. Maybe you can educate me and some of the individuals watching on that, but I just don't know what you're talking about in terms of risk. The risk is always going to be there if people copycat, but I just don't have any concrete examples of what we need to change in order to avoid, a suit on compelled association.
Am I calling myself next?
All right.
Oh, I'm sorry, was someone else ahead? Oh, Eileen, you can respond. I'm sorry, you respond first.
I'm not trying to do litigation risk assessment or avoidance. I am saying we need to look at the issues and the consequences. For example, the opt-in. We've already heard, well, we haven't heard. I have already heard from the chief financial officer that is going to potentially create an untenable situation for the Bar Association. That's an issue that should be discussed if we're going to make it as a recommendation. And the association issue is pretty clearly laid out in Janus, and I see Andrea nodding, and I think it applies to more than ATJ and Minority and Justice. I think it potentially applies to some of the sections. It potentially applies to some of the standing committees. And it may be that the Supreme Court shows deference to state bars and that it says we are going to leave Washington's decision on this alone. However, I am very conscious that Justice Alito's decision under the less exacting, Andrea's nodding again, review standard for First Amendment found a violation, but clearly left open whether or not it would be a strict scrutiny analysis, in which case there is a very difficult time building. We would need to be prepared to respond to that. I agree that there are ways in terms of the values, the professional obligations. We have some of them already, that you don't turn away a client based on race or gender. We have incorporated that into our professional standards. And I think that there are ways to discuss the appropriateness may be in a slightly narrower fashion on access to justice and diversity. But I don't think we can just say it ain't going to happen or that it's a copycat lawsuit. It doesn't matter if it's a copycat lawsuit. If it's successful, it's successful. So I just think we need to be prepared both to discuss what Dan Clark's email identified, potential financial considerations, fairness to employees, to people who have signed contracts with the state agency, to be prepared to tell the legislature this is what needs to happen with the legislation that's now on the books and or the bill that came out at the end of the session, and not necessarily to make decisions on any of those, but to identify them as issues with consequences that will need to be addressed. If we want to wait until somebody sues or keep our fingers crossed that nobody will, that is one approach. I am not that patient a person and prefer to be more proactive, but that could be a recommendation from this group.
So, calling on myself, I want you to know there have been lawsuits filed. They've been filed by people who file a lot of lawsuits against us. They, to date, have not been successful. One of the ones who has sued us was at the last meeting, taking notes on the antitrust presentation. So far, you wouldn't call them nuisance suits, but they've been pretty summarily dismissed, first by the district court and then by the Ninth Circuit. They've sought review at the U.S. Supreme Court. I'm not sure. I can't remember what their status is. They might still be in a pending fashion. I don't think at this time they have been developed in a way that the U.S. Supreme Court would accept review. So at least a couple of our members are all over it and have sort of done it sort of as an add-on to their other complaints that they are bringing usually against the Bar Association and against the Supreme Court. I appreciate people talking about access to justice and diversity and equity and inclusion maybe being in or out or where it is. However, my understanding is that was the argument that was made to the legislature to get them to not make the bill go forward this time. House Engrossed Substitute Second, House Bill 1788 was sort of on track, and it was, I think, the intent was just to give us sort of the work group and the Supreme Court full authority so you don't have to go back and have the State Bar Act thrown in your face as a potential done. Others viewed it as taking away authority or putting at risk these things that I never would have considered to be at risk, but they did, and those were the arguments that were made. And other negotiations were done at the end, or not negotiations, but power plays, I would say, were done, which resulted in them running out of time to actually make a decision to move it forward or not, and so therefore it died for this session. So I think, at least at that time, they were being used as swords or shields, whichever way you want to view it, to do it. So I think we do have to discuss it, whether we think it's in or out, and if it's in, what are the best ways to, do we think it's in just based on what we already have? Do we think it's in, be more in if we recommend the Supreme Court make it more tightly aligned? Are there people who don't think it should be in at all? So those are how, and I sort of see that on some of the various different issues. I'm going to go to Mark and then Dory.
So, I think that as far as, I would favor that our Bar Association defer to the judgment of our Supreme Court that diversity and inclusion is, and access to justice, are core values.
Right.
I think our court has found that. And realistically, however, all of the cases that have been filed, the First Amendment cases, have all specifically attacked those programs. That seems to be, the hot button. They also attack the legislative programs. But starting with those two programs, in 2016, the Supreme Court reauthorized the Access to Justice Board. And I think that order is good to look at. In 2013, the Board of Governors adopted the Diversity and Inclusion Plan. And the language from that plan, I think that, even though GR 12-2A, under the purposes of the bar, discuss diversity and inclusion and access to justice, I think we can strengthen that a little bit and make it coming from the court. And so if the court were to do something for like diversity and inclusion, like the Board of Governors did in 2016 with the Access to Justice Board. So this is the language from the Board of Governors in 2013, that the business of attorneys, employers, and clients call for more diverse legal representation across the state. It's the policy of the Supreme Court. It's the opinion of the Supreme Court. WSBA recognizes the need to enhance opportunity in the legal profession, the public's experience with lawyers, by demonstrating to its members and the public at large that a genuine commitment to supporting and advancing diversity and inclusion. The plan reflects the unique roles for which the WSBA is positioned as a unified bar to create and nurture the conditions that will encourage diverse lawyers to enter, remain, thrive, and ultimately lead the profession and inspire others to follow in their footsteps. And then you have GR 2A6, the purposes of the bar. So I think if we're talking about if we're talking about keeping these programs, if that's the sort of the will of, it certainly I think is the will of the court, and but then I think we can do a few things to risk an argument that the connection between the Supreme Court, our regulatory authority under the Constitution of Washington State, is strong, and that is a court policy, not a WSBA lawyer's policy. So I think that those suggestions, if it's the will of this task force to keep those programs and to maintain those programs and have our members fund them, which is what we're talking about, then I think the stronger we make the court's connection to those programs as policy, as court policy, pursuant to the court's constitutional authority to regulate our profession, it improves our chances of success if and when we do get sued.
Thank you. Dory.
So, as you've discussed the issues around association access to justice, diversity, and inclusion, I've heard a couple of themes. One is an opportunity to possibly strengthen the policy commitment and or attachment to the regulatory scheme within Washington to kind of prepare for the defense. I've heard Andrea and Eileen reference the need to potentially prepare to defend, and that being a strategy that the state could use for that. I've also heard discussion about, and how do you pay for it? And so I don't want to open another can of worms, but in case it's helpful for the group, maybe you want to have a conversation about what funding it looks like, because, well, up to now the conversation has focused on asking attorneys to pay, say, a level of dues to support this. What's to say that has to be the funding mechanism? And so I just, in case it's helpful, in case you want to think about, if not that, then what? And I don't mean, by the way, the Office of Financial Management and appropriations from the legislature necessarily going down that path, but maybe there's something else creative.
Well, I believe it is funded currently because we have it currently. So it's somewhere it's in the WSBA budget. The question is whether how that works with compelled speech or compelled association or, so I think that's how we have to think about it, or how we can better, if it is the value, which I believe it is, then through some more direct line to the Supreme Court, which is how other things are in or out. And I guess a reviewing court someday could decide that it's not appropriately in, and that's the risk you run. Or they could say it is appropriately in, especially if they're going to be giving some deference to us. I'm calling Fred, but I do want to say I want about 11:40 today we have a couple public members, at least one public for sure, who have come and have asked if because we took comments from the computer, that we would allow them. I was planning we would have more opportunity in the next meeting to do that, but since they're here, I think it would be nice to give them a courtesy. So in about 12 minutes, I'm going to cut off our discussion, let them make their, hopefully, short comments, and then we'll talk about our next steps. So to you, Fred, and then Andre after you.
If Mark's comments were a motion and this were a board as opposed to a work group, I would second them. I think that those were right on point, and I think eventually I hope that that's one of our suggestions to the Supreme Court. To put it a little bit more in context, I'm not as pessimistic as Eileen. I really follow. I think I would have written another memo, and I thought about writing a memo, not just on the antitrust, which I did, but on the free speech and association issues. I didn't write it because I read Professor Chemerinsky's piece, and I gave that to Dorian some materials. I'm not as pessimistic about our future if we do some things like Mark has suggested. Judge Alito wrote an opinion, about 4 years before his last one, where he made it clear that bar associations were different. And I don't think 4 years in his mind is going to change his position, that bar associations are different, so I'm not as pessimistic. One last point is that we've all kicked around, was it Hunter, your, the opt-in versus opt-out, or was it yours, Kyle, that thought, and we all sort of nodded and thought that seems like a good idea, and then I hear from Eileen that maybe the bar thinks it's a problem. I'd love to hear from the bar about that opt-in, opt-out. Well, it sounded good to us. Are we creating some problems that we don't know about? And I don't have a position on that because I haven't heard about how problematic that might be. Thank you.
Andre, did you have something, or you were clarifying?
So that was my add-on, was we have an April 8th, 2019 PowerPoint presentation of sorts. Maybe we can expand upon that in light of some of these questions that were bubbling up. Because I think it does come down to dollars and cents to a large degree, but that's not all of it. But certainly having the bar staff talk about, or someone in the bar, talking about whether or not it's feasible for us to do the Keller opt-in and maybe even do other things and what would be the consequences. And I think, Eileen, that's kind of what you're talking about, is raise the issue and then what are some of the consequences downstream. So,
Kyle.
Thank you. When I first mentioned the opt-in approach, I did that as, this is something to explore. Did not intend in any shape or form to imply that we would not be talking with the Bar Association and be in complete partnership with that. And we probably should reserve some time, we can talk about that, to discuss whether it's feasible. I got to think that in some form or fashion, it would be feasible. You can take the all-in approach where you would throw in a lot in the opt-in, or you can look at it narrowly. So that's another discussion topic that might, feed into that topic when we finally bring the Bar Association in to discuss, is it feasible, and then how do we make it feasible? That was my idea.
Yeah. I think it makes sense at the next meeting to have Ann and or Jean, whoever is working on the Keller, or both of them, I'm not sure who's involved, to talk about it, because I can see in one sense it sounds pretty slick. In another sense, there's a certain amount that is the cost for doing it. And if only 10 people opt in versus, or 1,000 people opt in versus the whole membership, that really shifts the cost, because the cost still has to get paid for if we're doing it. So I can see why perhaps an accountant or a CPA's mind would go, "Ooh, how do we do that?" At the same time, I think it's worth exploring, because if it could be done in a way, or if you could just have it built in that there's an automatic review and that this is the number before it even goes out, so there's just never a challenge. Instead of a challenge after, you've laid all the groundwork going in. So I think Keller is something we do know is on their mind, and it would be good to have a little time with that and understanding it. On some of these, I thought we would try to sort it out ourselves, whether we think it's a good idea, before we even ask bar staff to look at it, because if we are saying we don't think this is a good idea, we don't have to take their time. If we think they're viable or something we want to consider, then I think having that extra information, and to the extent we can give advance thinking as to what we might want it on, they can be prepared. Because, we have one more official meeting and we have two more optional meetings, which I'm feeling we're going to be using both of those. But I'm hoping not to go past the two more optional meetings. So we're gonna get, today was a day to really kind of let it, people just, in my mind, where are we, how are we thinking? I mean, we haven't really used the matrix, but having the matrix helped us have the conversation. And I think we probably come back next time with a matrix that has these specific things and what's involved or what's not involved, with these discrete ones that are sort of the big blocks that we've been, ATJ, race equity and inclusion, the Keller deduction would kind of be ones where I think we would spend a lot of time, or some amount of time, in sort of fleshing out what that means. I have no other, I have Eileen's hand up. Eileen.
Well, I had asked bar staff to do a kind of a cost center analysis
Yes.
that would be part of a discussion on opt-in or opt-out. And they started it, but, and did one just on the Office of General Counsel, because that's, unlike the section, I mean, that clearly, that is not a money earner, to look at both its functions and its cost. And we agreed that to go beyond that without some guidance of how the court or this group was going to give at least general outlines of what's in the regulatory function, so that they could take that and do cost centers related to those pieces, that it probably wasn't a good use of their time right now. So I don't know if we would be able to do it before the next meeting, especially since we have the public comment period. But if, and again, and I see Ann isn't even here, but maybe Tara could speak, if we could give them even chunks to look at for the cost center analysis, perhaps that would be helpful. I don't know. Tara would have to answer that if you want to do that. But I just raised that, and it was started, but it was felt that without a little more guidance, it wasn't going to be the best use of bar resources and time.
I think if you can give us a clear sense of what you're looking for, we could probably get portions of it ready for the next meeting. So if there's particular areas that you have questions about, I do think it would be a pretty heavy lift to get the entire organization done by the next meeting.
Right. I think that'd be too much, and I think that's more either later of our meetings or possibly more detail when we decide what the Supreme Court is thinking or not thinking. It'd be helpful for us to have some, but I think a lot of the bar stuff, we're not, at least in my view, we're not doing like a budget review of the whole thing, because that's not the question. What we're doing is we're looking at specific areas where we perceive vulnerability and understanding if we were to change it, what would that cost? Or if we were to eliminate it, what revenue goes away? If it stays as it is, how does that affect it? So, at least in my mind, and I'm not sure if I'm thinking of it the way Eileen was thinking of it, and I might not be. Eileen has perhaps more, from her background, better experience. So why don't you speak first, and then we'll see what Tara says.
Oh, well, I do think there are certain core issues where we would have agreement that bar functions would fall under, some super safe zone, licensure, admissions. Right. And then there are certain related functions, like the Office of General Counsel, which is involved in all of those, that if we could have an assessment of the costs in those areas, and I wouldn't want, not a budget, no, I mean, that's just a level of granular detail, but to have a sense that what would that mean in terms of if, and not saying that we concluded that things outside those agreed areas, but what would be the implication for them if you take that narrow perspective financially? And and not to create some kind of conclusion that everything outside these narrow areas isn't part of the bar, but to give you a picture of, is it really going to be huge? Is it going to be minuscule?
Right.
That's what it was. That
Okay.
Did that make sense, Tara?
I think it's more to scale. So things that I think, and we can identify it, I think even with the time we have left, that most people would think are beyond question regulatory. That what is that? Is that the bulk of what our dues pay for already, or our license fees? Or is it actually not, and is most of our license fees going to what would be considered arguably by some non-regulatory by the virtue of us being an integrated bar? So even like people think they're going to have all these savings. Well, are they in fact? Maybe yes, maybe no. And then as other things are deemed to be essential to what would be money coming into the regulatory side of the house versus money coming into a more voluntary sort of the house, and who's governing it if we do a hybrid. I think, is that what you're saying, Eileen? Yeah. So it's not the deep dive. It's more of a sort of a bigger dive. And I think Paula did a lot of that before when she was sort of the big sheet we had before us to sort of the different directors presented. So I think it's a bigger number, I think, than the detail that perhaps saying cost centers made you think.
Can I respond really
Yes,
quick?
please, Tara, and then I'll
So
go to
I don't
Mark.
want to speak for Anne or her team because she'll tell me what's possible and what's not. I suspect a high level analysis will be easier than detailed. I'm glad you raised the spectrum chart because one thing I did want to point out is obviously our budget is organized by cost centers, and those cost centers have nothing to do with regulatory versus non-regulatory. So getting into dividing up those cost centers, that is where the challenge lies. And in particular with the spectrum document, one of the things we've talked to Eileen about is that when we started that, I think it felt somewhat obvious what belonged where, but the more we dove into it, the less obvious it became. And so I would just caution, again, I mean, if it's for illustrative purposes, that's one thing. But if it's sort of really getting down and parsing it, it's just not as clear as it might seem.
Right. Well, and part of it is where it makes sense to group it for organizational. It's different where it would make sense if you were using different dividing lines.
Right.
So like, I don't know where client protection fund is.
Right.
But arguably that could be considered regulatory.
Right.
But it might not be in an area under a cost center that would be considered that.
Right.
So, got it. Hunter, and then I'm going to go to the public because I want to have a little more time at the end to talk about the future. Did I have another hand? Andrea? Okay, so I have. Thank you. Andrea, you're first. Hunter's deferring to you.
It was just a really quick question, and thank you, sir. For Tara, and I'll defer to you.
Sorry. Tara, I'll defer to you and Anne, but I was wondering about that one chart I remember we got at, like, it was a training, it was like a circle pie thing, and it talked about like the dollar for, and I don't know if you think that would be helpful or not in terms of this, I don't.
Yeah, I think that might be helpful.
Okay.
So I was thinking of that too for sort of the high
Yeah.
level look at,
Okay.
so we can share that, yeah.
Thank you. Hunter? Or was it Mark? It was Hunter.
Well, can I just have a comment. You know,
Okay.
the budget, the Board of Governors budget which was adopted in September of last year, is available on the bar's website. It includes the cost centers. It's a really good document. I mean, you can get a lot of information from it. So, the link to the thing is a mile long, but if you just
We'll
Google
send it to you.
Yeah, it's a great document, and it provides a lot of the insight I think that we're talking about.
Okay. So now I'll go to Hunter. Thank you for letting cuts.
Of course, yes, thank you. And I do think the financial conversation is interesting, and it's kind of the next logical follow-up, or one of the next logical follow-up areas of discussion if we were to go down what I propose, the fork in the road of change versus non-change. And as I'm hearing the various conversational pieces out there, there are two things that strike me that I thought might be helpful for me to share here as we kind of wrap up. Is that one, if we go down a no change or more of a status quo type fork in the path, it strikes me that, in effect, we're saying a couple of things. Maybe not deliberately, but the effect is that, one, that we believe the current structure is sufficiently important or sufficiently defensible to where we prefer to take on any Janus-related exposure, or at least the constitutional issue that is associated with it, as part of the cost of keeping our current model. And I don't think it's engaging in litigation assessment to at least acknowledge there's an issue there, right? I think there's some very smart people who say there is an issue here. And we don't necessarily have to predict how the U.S. Supreme Court is going to come down to at least recognize that if we keep the status quo, we are affirmatively taking on that constitutional issue and saying that's an acceptable price for us to keep and maintain what we have. The second piece is, as I said, the financial piece is fascinating because it's been pointed out by a number of people that for those states that have adopted a voluntary model, that they experience a reduction in the number of members who choose to remain affiliated with that organization. And I would say that is absolutely regrettable, but it also illustrates the very nature of what we're dealing with here, that we have a number of, I believe I'm safe in saying that we have, just based on the public comments, that we have members who, given the choice, would either choose not to affiliate, and I would disagree with that choice, but that's the choice that they presumably would make, or they would choose to solely associate with the voluntary model. And what we would be saying if we, again, recommend no change would be that we hear you, we respect that perspective, and yet we believe the model is sufficiently meritorious to keep you in this organization, and we want your money. And so, thank you.
Okay. If it's all right with everyone, I'd like to hear from the two people who wish to make public comments. I'd ask you to go to the microphone, identify yourself, and recognize we still want to have about 15 minutes when we're done to talk about next steps.
I will try to be as brief as possible. And first and foremost, I want to thank each and every one of you here for volunteering your time for the work group structure. I am very impressed. I am only wanting to speak to help and encourage and inspire you for leadership to help protect the 7.5 million people of the state of Washington. And I am here to also help and support the 145 people that work at the bar, okay? Because when we look at the bar, and we look at the State Bar Act, and we look at the over 100+ years of tradition in the legal profession, there is not a single person of color that actually had a voice in the State Bar Act. There is not a single female voice that had a shaping in the State Bar Act. And I think it's about time that we look at the work group structure, that we look at these institutional changes of how we can help protect the civil liberties and how we can help protect the idea of the judicial system so that everybody can be seen as an equal under the law. And that is why I'm here. I am here to help support mandatory malpractice insurance, which did not pass, unfortunately, but the Supreme Court can still implement on their own. And the reason why malpractice insurance is so important is because it's not a requirement, but it is a requirement for triple LTs and LPOs, so there is an extreme antitrust implication, and it opens, unfortunately, the bar and the Supreme Court up to lawsuits. So I believe that mandatory malpractice should be something that should be looked at some point. But additionally, lawyer discipline system, which is the front line of defense to protect the public, I think is something that should be thoughtfully talked about, to have thoughtful discussions, not as condemnation about the current system, but it's how to proactively look at the protection systems that we have in place. Are they sufficient? Are there gaps? Do they allow for victims like myself to not even have a day in court and have judgments against them left and right? I think that we can be a little bit curious. I think that it is still imperative to have the Office of the Attorney General do a review on behalf of the people, to look at the systems that are in place, to make appropriate recommendations to the Supreme Court of the types of changes that are best to institutionally protect the citizens of Washington, to protect the judiciary, to alleviate from burden of anything, because it is my contention that when it comes to the court and the judiciary, they should be free. They should be free from the burden of having to be responsible for the lawyer discipline system. Because it can't be fair and impartial when people bring suits. It's deeply troubling. It's troubling to me because the attorney that I was affected by not only was under investigation by the bar, but she admitted that she conspired with a law professor at one of the most prestigious schools in the state of Washington, that it is okay not to comply with the Office of Disciplinary Counsel, and this person's teaching generation of future attorneys. Teaches ethics, no less. An ethics teacher is telling an attorney, while under investigation, not to comply with the Office of Disciplinary Counsel, that, quote unquote, they'll be mad as hell, but they're already mad at you. I think it's time for a review on behalf of the people, because one has never been done in the history of the bar. There has never been an independent review of the lawyer discipline system, ever. And again, it's to support the Office of the Disciplinary Counsel to
That's
recommend
actually
changes.
not accurate. The American
There
Bar
has-
Association comes in, we ask them to come in and they do a whole review. And every so many years, we have done that. They just wrote recently, we are not doing it right now because we're going through this to see what we end up with. And I'd like you to identify yourself. I know you've spoken in the past,
I
but I can't
apologize.
remember.
I apologize. My name is Kevin Michael Watley, and I am a public member. And
Okay,
if
Kevin,
the,
you've had 5 minutes, and I want to be sure the other woman has
Sure.
an opportunity to speak as well.
where would I find that review?
Where would you find what?
The review, the independent review?
There is a whole, the bar will have it somewhere on their website, and I'm
Okay.
sure Doug Endy could direct you to that.
Perfect. But nonetheless, I still recommend the Office of the Attorney General to do a review on behalf of the people. Thank you.
Thank you very much. Please, Winnie.
Hi, I'm Winnie Okur. I'm on the Executive Committee of the Animal Law Section. It's my life. And I only want to speak because I've heard several times today that the Animal Law Section is an example of a section that has been losing money and costs the Bar Association money. And I have been on the Executive Committee every single year since its inception. I've been the treasurer many years, and I can say firsthand that every single year, our volunteer CLE revenues have left us with at least $10,000 balance, according to the budget information that we receive every year. And the Executive Committee goes over it a great deal. So I must say that there is some sort of financial disconnect here, because we get information from the Bar Association when we prepare our budget every year that tells us we have at least a $10,000 balance allocated to our section. And yet, time and again, here and in previous meetings, I have heard the Animal Law Section and the small sections be used as an example of a cost to the Bar Association that we're not paying our way, so to speak. And I'm sure the Executive Committee, the rest of them, would be aghast to hear that, because every year we're very careful to see how much money we have in our budget. So I want to echo what Paul said, that there is some sort of budgetary disconnect going on right now with respect to the sections. Is all I can speak to, and that's all I wanted to say.
I really appreciate the clarification, Winnie. I was one of the ones who made the comment, and it's just because what I have heard, not because of my own independent verification. And there may be small sections that's true for, or it may not be true for any of them. And so I think that's a good point for us to confirm one way or the other with the bar staff, and then if there's question, then hear from the sections. And we have on our work group people who represent the who come from small sections, come from medium sections, and come from large sections, so we were sure to have those voices. So that's very helpful.